Hi, everyone. Vlad Portnoy here. It's Tuesday, 12 noon, and that means one thing. We are yet again addressing your concerns and answering your questions that you've sent to us over the past week. So please feel free to continue reaching out to us and asking your questions because chances are, if you have this question, someone else does too. So you'll be helping yourself and others. And here we go. Who should manage money for your special needs child if you're not around to do so? Well, with the proper planning, you would appoint a successor. There are two different types of persons who will be taking care of your child. There's a guardian of the child's person and property, meaning daily needs, and that guardian is appointed through surrogate's court upon probate of your will. So make sure you have a will and you designate such guardian in the will. The other person is a trustee of a special needs trust that is set up specifically for your child's benefit. And the key term that is in the trust is that the money is meant to supplement but not supplant the benefits, which means it's available in a proper form, but it is not readily available to the child, so the child may be able to keep their benefits and benefit from the funds that are in a trust. The difference between a first party and a third party special needs trust, or really any trust, is that a first party trust is funded with the child's own money. For example, a child or a parent on behalf of the child settles a medical malpractice lawsuit or a personal injury, or a child gets an inheritance through someone's will, specifically with the child's name in the will as a designated beneficiary. That money must go to a first person special needs trust, which is basically the child being their own grantor and beneficiary. And the third person is if someone else does the planning for the child, for example, parents or grandparents that are a third person in relation to the child, and they set up a third person trust and fund it with their own money for the child's benefit for the future. The key here is that the proper planning, if possible, should be done with a third party trust. Why? Because in a first party trust, there's a Medicaid payback provision, which means any funds that are in the trust that are not used by the time of the child's death first must be applied against anything that Medicaid paid for this child's benefit. And potentially, unless there's billions of dollars in the trust, it will wipe out the trust and there will be nothing left. The third party trust, because it is not funded with the child's own money, will actually the third party trust, because it's not funded with the child's own money, but with someone else's money, does not contain this provision and will go to the child's next of kin or whoever you designate as successor beneficiary upon child's death. Choose wisely, plan wisely. The question is very general. Will Medicaid take my special needs child's inheritance? And I presume the question is, if that inheritance goes through the will. Remember that that Medicaid is a public benefit program. It is a privilege, not a right. You have to qualify to be on Medicaid by your income, your resource, and your health conditions. So if the child receives the money outright, there are last-minute planning techniques that could be utilized, but it also may be detrimental to the child's welfare. And Medicaid will not be taking the money, but Medicaid will not be helping the child until the money is dealt with. And under certain circumstances, the money can be safeguarded or a portion thereof. But under others, there's a possibility that the child will simply not be eligible for Medicaid until they burn through this money, which is not a wise plan, which is why we always recommend doing a living trust, a special needs trust for the child, and funding it with money so it doesn't go through probate, and Medicaid as a creditor does not come into play. So the question is, will my child with special needs lose benefits if I leave them money? If the money is left outright, absolutely you're jeopardizing every possible benefit your child may have. I don't even know your situation, but I can almost guarantee you all that will be lost because each public benefit program has eligibility rules. And number one rule is there can't be any other source of money to benefit your child. The other issue is that should the child actually inherit this money, they cannot refuse it. Or if they're minor, their guardian cannot refuse the money because Medicaid will deem that as fraud. So the only way to address this issue head first is to properly plan.